Today we are discussing about the most powerful legal tool available to a liquor shop owner, a hospitality business, or any excise licensee in West Bengal whose license has been cancelled, suspended, refused, or whose transfer or shifting application has been wrongly rejected, the writ petition under Article 226 of the Constitution of India before the Calcutta High Court. Hello friends, I am Advocate Sudip Patra, practicing in the Supreme Court of India and the Calcutta High Court. Whether you are a foreign liquor offshore operator facing summary cancellation, a bonded warehouse holder facing a multi-crore fee demand, or a retail vend owner denied renewal on non-statutory grounds, what I am going to explain today is the step-by-step process of challenging these excise orders in court and how to protect your business from day one. The first and most critical question before filing any writ petition is your case actually suitable for writ jurisdiction, or must you first exhaust the statutory remedy of appeal? Under Section 8(2) of the Bengal Excise Act, any order passed by a collector or subordinate officer is appealable before the Excise Commissioner. Under Section 8(3), the state government has revisionary jurisdiction. Because the Bengal Excise Act is a self-contained code with its own appellate machinery, the Calcutta High Court generally expects a petitioner to use these remedies before knocking on the door of Article 226. However, this is not a bar, it is a rule of discretion. In four specific situations, you can and should go directly to the High Court without waiting for the statutory appeal. First, where the impugned order violates the principles of natural justice, the most common ground, meaning no show cause notice was issued, no hearing was given, or the adverse materials were not disclosed to you before the order was passed. Second, where the authority that passed the order completely lacks statutory jurisdiction, for example, a superintendent issuing an order that only the collector can make, or a collector purporting to review and cancel a license on grounds outside Section 42. Third, where your fundamental right to equal treatment under Article 14 of the Constitution has been directly violated, for example, where one licensee in an identical situation was granted a transfer but you were denied. Fourth, where the very rule under which the demand or order is made is constitutionally invalid, as was successfully argued in the New Kenilworth Hotel case. Once you decide to file the writ petition, the drafting must be precise and strategic. The petition is filed as a writ petition application called a WPA on the appellate side of the Calcutta High Court, covering all of West Bengal outside the original limits of the Kolkata Municipal Corporation. If you are within the original KMC limits, it is a writ petition original called a WPO on the original side. The cause title must name the aggrieved licensee as the petitioner, with respondents listed as the State of West Bengal through the Finance or Excise Secretary, the Excise Commissioner, the Collector of Excise of the concerned district, and the local superintendent. In the statement of facts, you must clearly lay out the history of the license, when it was granted, what investments were made, how many years the business has been running, what the impugned order says, and on what grounds it was made. In the grounds of challenge, you must focus on Article 14 and natural justice, not on Article 191. This is a strategic point that many licensees get wrong. Since the Supreme Court has held in coded distilleries and Har Shankar that there is no fundamental right to sell liquor, relying on a right to trade will get you nowhere. Instead, frame the challenge as the state has established a licensing regime, it has framed rules, and it violated those rules while dealing with you. That is arbitrariness under Article 14, and it must be corrected. The prayers must ask for specific writs, certiorari to quash the impugned order, mandamus to compel the authority to grant the license or transfer or renewal, and if relevant, prohibition to prevent further adverse action. The prayer for interim relief is the most time-sensitive element of the entire petition. If your license has been cancelled and your shop is sealed, or if a transfer that your business urgently needs has been refused, every day of delay is a commercial loss. On the day of filing, your advocate can mention the matter before the determined single bench judge handling Group 9's residuary matters, which is the roster category under which all licensing disputes under the Bengal Excise Act fall, as opposed to Group 4, which covers revenue and tax disputes. During the mentioning, the advocate presents the urgency, immediate sealing of premises, active cancellation of an existing license, or the threat of irreparable injury, and requests an early listing. Upon being heard, the advocate must satisfy the three-part test for interim relief: a prima facie case, meaning there is a serious question to be tried; the balance of convenience, meaning the harm to you from refusing the stay is greater than the harm to the state from granting it; and irreparable injury, meaning no other remedy, including damages, can adequately compensate you for the loss of your business. Let me walk you through what the practical timeline looks like and what documents you absolutely must file. Before filing, you need the original license certificate, the impugned order, all representations you previously submitted to the collector or commissioner, proof of payment of license fees, and any relevant police reports, enquiry reports, or internal correspondence of the department that were relied upon to pass the order. You may have to seek these through an RTI application if the department has not disclosed them. The petition itself must be supported by an affirmed affidavit of facts. It must be e-filed through the Calcutta High Court's electronic filing portal with the applicable court fee. Prior to moving for urgent relief, physical and electronic notice of the entire petition must be served on the government pleader's office and the concerned respondents. Failure to serve notice will prevent the court from granting even an ex parte stay because, in excise matters, unlike some other writ matters, the court is generally reluctant to pass ex parte orders without at least notice to the state. Finally, one procedural pitfall you must avoid at all costs if you have already accepted a compounding fee under Section 65 of the Bengal Excise Act, or if you have voluntarily participated in a fresh tender process after the adverse order was made, the court may hold that you have waived your right to challenge the original order. As the law stands, delay, laches, and conduct after the adverse order are three of the most common grounds on which writ petitions are dismissed at the threshold. File promptly, act consistently with your legal position, and challenge every step of the way with the guidance of an experienced advocate. If you need professional assistance, Patra's Law Chambers is available at the number shown on your screen and at www.patraslawchambers.com. Subscribe to our channel to get this kind of more updates.